Hey everyone, Brandon here from TruckSafe Consulting. If you've been following trucking related news for any length of time, you've undoubtedly heard the buzz about so-called nuclear verdicts and their rise to prominence in this industry. Recently, we saw the largest such verdict, $1 billion, entered against a couple of trucking companies in Florida following a catastrophic accident. Now, in other videos, we've discussed the driving forces behind these types of cases and the steps that motor carriers and their drivers need to be taking to minimize their exposure. But in this video, I want to tackle a topic that's come out of this most recent Florida case that's particularly troubling to me. And it stems from a statement made by the attorneys for the plaintiffs in that case, which I think is misleading. In fact, it's the type of generic statement we see come out of a lot of these cases that typifies the so-called reptile theory of litigation. So stay tuned, and if you're watching on YouTube, be sure to hit the subscribe button below to stay up to date on all of our DOT related content. So I want to preface this video by saying a couple of things. First of all, I wasn't personally involved in the Florida case, nor have I reviewed all of the evidence from that case, so my thoughts here are just my gut reaction to the statement made by the plaintiff's attorney following his particular case, and more broadly in other similar cases, which I think deserves a lot more context and clarification. And second, I'm in no way trying to minimize the circumstances of this accident or others. I feel awful for the victim and his family, and from what little I know about the actual facts of this case, it seems that the commercial driver involved should not have been out on the road. That said, this case and the statements made after it really exemplify what has become known as the reptile theory, which is a tactic utilized by some plaintiffs' attorneys to put a motor carrier's reputation on trial rather than the circumstances of the actual accident, and thereby appeal to the emotions of the jury and secure larger verdicts. The problem is, this isn't how our American legal system is supposed to work. Judges and juries are tasked with deciding the specific case that's before them, not any prior injustices that speak to the overall character of the defendant that's on trial. You know, the reptile theory is pretty predictable. It casts the motor carrier as a bad actor with a history of regulatory violations and unsafe behavior. Often the facts of the actual accident take a back seat in the litigation if they're even addressed at all. And as a result of the increasing prevalence of this type of litigation tactic, we've seen some of the largest verdicts entered against trucking companies in the past 5 to 10 years. More recently, we've seen trucking companies and their various interest groups start to fight back, including through legislation that's aimed at curbing such lawsuit abuse, such as Texas's HB 19. So with that background in mind, I want to take a critical look at the types of broad statements typically made by the plaintiff's attorneys in these cases, and we'll use the most recent Florida case as just one example. Following that case, the plaintiff's attorney stated in part that the trucking company recklessly hired the driver and put him on the road in violation of every regulation on hiring, training, supervision, dispatching, and entrustment of commercial vehicles over the road in interstate commerce. Now, the biggest problem I have with this statement is that it's obviously hyperbole, aimed at evoking emotional reaction from the reader or listener without any apparent concern for the truth of that statement. How do I know it's hyperbole? Because after many years of closely studying the federal motor carrier safety regulations and equivalent state regulations, I understand that those regulations have, believe it or not, very little to say about hiring, training, supervising, and dispatching drivers. And so when someone claims that a carrier's decision to hire a particular driver violates every regulation in the books, I have to roll my eyes a little. Again, to be clear, I'm not saying that the driver at issue in this case should have been on the road. In fact, based on what I've read about the case, I'm inclined to think he probably shouldn't have been. But whether carriers are negligent in allowing a driver to get behind a commercial motor vehicle at the time of the accident based on their driving record, for example, or past conduct, that's an entirely different question than whether the carrier has actually violated the regulations by doing so. And it's the second question that the attorney implicates in his statement and that I want to explore. Because if it's not true that the carrier at issue violated every regulation on the books by hiring this driver, then I think it's pretty clear what's going on here, and it really just gives the legal profession a black eye. So what exactly do the federal safety regulations and their state analogs have to say about a motor carrier's decision to hire drivers? Well, the answer to that question is going to be found in parts 390 and 391 of the federal safety regulations, which are in Title 49 of the Code of Federal Regulations. Part 391 specifically is dedicated to minimum qualifications for commercial drivers, and it dictates whether or not a driver can be used to operate a commercial motor vehicle. Simply put, if a driver meets the minimum qualification standards set forth in Part 391, then he or she can lawfully operate a CMV. Now, whether or not it's a smart idea for him or her to do so given their driving record, that's an entirely separate question. As a preliminary matter, the regulations establish a system whereby regulated motor carriers are responsible for ensuring that all of the drivers who operate under their DOT numbers are fully qualified before allowing them to get behind a CMV. Section 390.11, for example, provides that whenever the safety regulations prescribe requirements for or impose restrictions on drivers, it shall be the duty of the motor carrier to require observance of such duty or prohibition. So if we then dig into Part 391, we see the general qualification and disqualification provisions, which are the baseline standards that an individual must meet in order to be considered qualified to operate a CMV. Section 391.11, for example, says that in order to be qualified, a driver must, number one, be at least 21 years old, number two, be able to read and speak the English language sufficiently to converse with the general public, to understand highway traffic signs and signals in the English language, to respond to official inquiries, and to make entries on reports and records. Number three, by reason of experience, training, or both, be able to safely operate the type of commercial motor vehicle that he or she drives. Number four, be physically qualified to drive a commercial motor vehicle in accordance with the physical standards in Part 391, meaning that the driver has a valid medical card. Number five, have a currently valid commercial motor vehicle operator's license issued only by one state or jurisdiction. Number six, the driver must have prepared and furnished the motor carrier that employs him or her with a list of violations or the certificate required by Section 391.27. Number seven, not be disqualified to drive a commercial motor vehicle under the rules in Section 391.15, which we'll address in a second. And then number eight, have successfully completed a driver's road test and been issued a certificate of road test in accordance with Section 391.31, or have the equivalent to that road test as specified in that same regulation. So those are the basic standards a driver must meet to be qualified to operate a CMV. The remainder of Part 391 is devoted to adding additional flavor to the various bullet points that we just mentioned. But generally speaking, if a driver satisfies each of these bullet points, then the carrier has confirmed these facts, then the driver can lawfully operate a CMV. Notice that this stands in stark contrast to the overgeneralized statement that you'll hear from plaintiffs' attorneys in these reptile theory cases that a carrier has violated every regulation in the books by hiring a particular driver. The truth of the matter is that so long as the driver in question meets the requirements that we just discussed, then he or she is qualified and the carrier has not, in fact, violated a regulation by hiring him or her. What the plaintiff's attorney should instead be saying is that a carrier acted negligently by choosing to hire a driver who had a bad driving record. This is an important difference because in the latter scenario, we leave it up to the judge or jury to decide whether the carrier's decision to allow an otherwise qualified driver to operate based on his or her driving record was reasonable under the circumstances. But under the former scenario, the carrier's proven violation of a particular regulation may on its own be considered negligence per se. Now, before we wrap up here, I want to mention a couple of other sections of Part 391 that are important to determining whether or not a driver is qualified to operate a CMV. First up is Section 391.15, which is titled Disqualification of Drivers and includes a list of specific offenses that render drivers unfit to operate a CMV for particular lengths of time. I won't go through the entire list here, but generally speaking, these include things like the loss of driving privileges, for example, a license suspension, as well as certain criminal conduct involving the operation of a CMV, like leaving the scene of an accident, violating the federal drug and alcohol rules, and committing a felony while using a CMV. Each of these offenses carries specific disqualification durations, but what you'll notice here is that contrary to popular belief, the regulations don't impose any type of prohibition against drivers who have accumulated most types of non-criminal violations. In other words, the regulations don't render a driver disqualified to operate a CMV just because he or she has accumulated 5, 10, 20, or more moving violations over the course of a certain time period. And this is really the key takeaway here. While checking a driver's driving record is critically important to a carrier's onboarding process, we need to be careful to distinguish conduct that is disqualifying under the regulations from conduct that is disqualifying under the carrier's own internal policies. Many carriers, for example, will set a threshold of, let's say, 5 to 10 moving violations in the past 5 years. Applicants who have more violations than that may be disqualified under the company's own standards, even though they're otherwise qualified under the regulations. Put differently, a carrier who hires this type of driver has not violated every regulation in the books by hiring the driver, assuming the driver meets the minimum regulatory standards we discussed previously. Is it negligent for the carrier to hire this driver? Perhaps, but was it per se unlawful under the regulations? No. So to wrap things up here, I just want to again emphasize that words do matter. And often when we hear someone exclaim that a carrier has violated every regulation in the books by hiring or retaining a driver, that's misleading. What they mean to say is that it was unreasonable under the circumstances for the carrier, knowing what it is alleged to have known, to hire or allow the driver to operate a commercial motor vehicle. And that's a decision that's within the province of the judge or jury. But it's an entirely different thing altogether for a carrier to actually violate the regulations by hiring a driver who's not qualified under Part 391 of the regulations or applicable state regulations. I think we would do well for all involved to make that distinction. For an even more in-depth look at the driver qualification process and what it entails, make sure you check out our comprehensive online regulatory courses over at trucksafeacademy.com. And if you need copies of any of the regulatory documents used to qualify drivers, take a look at our library of regulatory resources at trucksafeconsulting.com. Lastly, make sure you follow us on social media where we regularly post compliance-related content. Thanks for watching.